The state of Petrojam, due to its underinvestment and the importance of taking action, is not anything new put out by this government. The only difference between prior governments and now is that we're doing it. We're doing something. That we're actually taking action. That we're not talking about it and saying how important the thing is and then watching the value fall and keep saying, let's wait a little longer, let's wait a little longer, let's try a little harder, let's talk a little more, let's meet a little more. And nothing happens. So that is the difference. That is the difference. So when people talk about hasty and premature, contrived, that this urgency is contrived, I've even heard that put out there. I don't know what they're defending, Mr. President, when they say those things. And it could never be Jamaica and Jamaica's interest. But Mr. President, I know that there are people who say those things because they don't have the information. They don't have the facts, and legitimately they ask the question. And that's why it's so important for us to share the information, the facts. And that's why I've tried as best as possible. I've had 3 press briefings. I've been, on the talk shows. I've written articles. I've done as much as could be done sensitively without impacting negatively on the negotiation process, which has been underway. Mr. President, we've had frequently asked questions published in the press. We've been published in both daily newspapers. We've had them published in social media so that persons who are concerned could get information, facts, again, without prejudicing or compromising the negotiation which was underway. Because we have to understand, it's important not to get pulled into a convenient narrative about what should be shared if what should be shared compromises the Jamaican interest, or if it compromises a process that is underway. Because let us be clear, Mr. President, a negotiation, even at a commercial basis between 2 companies, so we're not even talking about 2 countries, bilateral relations with political implications. We're not even talking about that. If we're talking just about a commercial negotiation, Mr. President, that is something that is done privately. There's information that has to be kept sensitive because that is how the parties work through their interests and the process to get the best result. There are matters which are sensitive. There are matters which are not relevant and therefore not placed on the table or not shared. But you have a process and you try as best as possible to be faithful to it. Imagine how much more sensitive that becomes, Mr. President, when it is done at a country level. Imagine how much more sensitive those things are. And I've said it before, so I'll say it again to share with this House, of course, that since I was appointed in October to lead the negotiating team in respect of the repurchase of the shares, I have tried as best as possible to share without compromising the process. But one could never seek to put everything on the table, as some people are saying, and have a sensible negotiation. That's not how they're done. So I understand that everybody doesn't negotiate every day about commercial things, so that everybody doesn't understand that process, and they might therefore be persuaded by that kind of argument. But there are people who know better. There are people who understand, Mr. President. And when they put misinformation or try to mislead people about the implications of information being shared or not shared, I have to ask who they're defending. And the Jamaican people must ask. The Jamaican people must ask them, who are you defending? They must ask.
Mr. President.
So, Mr. President.
On a point of order.
Mr. President.
Point of order.
Mr. Brown, please.
Point of order. Clearly wasn't here.
Senator Brown, come on.
Sit, Bernie.
Stop shouting at the lady.
Senator Charles. Senator Charles. Senator Charles. Senator Charles. I think that Senator Brown was shouting at me, not the leader. Go ahead, Senator Brown.
Why is this young man gabbing like that?
Senator Charles, please. Senator Charles.
To abuse and disabuse.
Senator Brown.
Mr. President.
Hold on a little bit. Before you take the point of order, I hope you listen carefully to what the leader said, because I was listening, and she didn't call anybody's name. She never called anybody or implicate any individual. So if you want to take the point of order, let me hear what it is.
Mr. President, I'm a first just apologize for the shouting. But as the Speaker in the British House of Commons do sometime to get attention, he says, order! And I'm just trying to get yours because the minister continued to speak while I rose. So I apologize if you and the House and the Senate is offended by the attempt to get your attention.
Senator Brown, I accept the apology. Can I hear the point of order, please?
But you must at least allow me the courtesy to apologize to you if you are offended. So, having done that,
it take a little more to offend, but I accept the apology. But go ahead and let me hear the point of order.
I want to move to the point of order. Mr. President, the government comes and says they want a national approach to this. But it is well known that member of the House of Representatives for Central Manchester raised issue of the valuation.
Senator Brown,
and that the comments being made by the minister is imputing motive to the member of Central Manchester.
She did not. That's not Senator Brown, I hear you. It is not a point of order.
Mr. President, I raised it. You have ruled, and I accept. But I still feel it is imputing motive.
Minister,
but we will come to that. We won't call names. And I hope nobody vexes when we don't call names.
Mr. President. Mr. President. Mr. President. Let me continue to share the facts about how we have gotten here. Right. So, Mr. President, what I could say is that, so we had moved from 2008 maybe to maybe about 11, change of administration. Just spoke about the then Minister Paulwell and his assertion that the refinery would have to be shut down if it were not upgraded and expanded. And perhaps the next interesting and important set of activities to note in the process is that was again made public by the then Minister responsible for energy, Philip Paulwell. And this was made public in a Gleaner article dated February 18, 2015. And in it, then Minister Paulwell advised that PDV Caribe had in June 2014, and I made this public in a press briefing before, but it's important that the Senate hear this as part of the process as well, that PDV Caribe had advised the government of Jamaica in June 2014, that it was seeking to sell its 49% shareholding. So Minister Paulwell advised on February 16, 2015, that he had received this notice about the prospective sale discussions that had started in June, and he announced that he would have a definitive announcement to make on the matter within 30 days. He alluded to the fact that the government of Jamaica might be willing to give up some of its shares because at that point, 30 days. He said the government might be willing to give up some of its shares to sell them in order to facilitate investment, and said that he didn't think that the government needed to be a majority owner of the refinery, and that maybe the sale would be a way to fund an upgrade, which didn't seem to be affordable to Jamaica. So in February 16, 2015, he says in 30 days, he's going to make a definitive statement, update on that. Good question. Nothing. 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 February 2015, 1 year before the election. There was no election that happened then. What happened then? Nothing. Notwithstanding his strong belief at that time that a sale was going to happen, that an upgrade was going to happen. Things were happening.
I know you're coming, waiting.
So, Mr. President, and discussions were taking place. It's quite clear they were exploring the ability to go forward, but nothing resulted. So, Mr. President, a year later, there was an election, indeed.
How longer? 1 year.
And
Not 30 days.
given the clear importance of the upgrade still as a matter of policy, in May 2016, just 3 months after the elections, Prime Minister Holness and senior members of his cabinet met with President Maduro and senior members of his cabinet to discuss how we would go forward, among other things, of course. But at that meeting, a commitment was given by President Maduro that within 3 months, action would be taken on the upgrade. Even with that level of commitment and efforts consistently being made at the technical level, it took us until January 2017 to sign a letter of intent, and that was signed between the Prime Minister and the President in the margins of the CELAC meeting in the Dominican Republic, January 2017. And it was then in February 2017 that an agreement called the Agreement in Relation to the Kingston Refinery Upgrade Project, the RUP agreement, I'll call it the RUP agreement from now on, it was signed between PCJ and PDVSA, so PDV Caribe's parent company. That agreement expressly recognized the joint venture agreement and how important the refinery upgrade and financing of it was. And one example of why we are where we are, Mr. President, is to be found in this most recent agreement that was signed. Because that agreement was supposed to reflect the commitment of the two heads of government to a new energy behind getting the refinery done. And in that refinery upgrade agreement, it stated that a task force was going to be appointed 5 on the Jamaican side, 5 on the Venezuelan side, in order to coordinate and execute. Those are the words, to coordinate and execute the actions needed to implement the agreement. So we appointed our 5. Venezuela appointed 4, never appointed the 5th, who was supposed to have been a critical, technical advisor in the process. But not even the 4 persons attended not even one of the 18 meetings scheduled. 18 meetings scheduled. They were given notice and invited each time, and not once did they attend. Not once, Mr. President. So Petrojam proceeded with the meetings anyway, because remember, we're saying this thing is critical now. This is critical. But it demonstrated clearly the lack of real commitment to implementing what it had signed to and what it said that would be done.
Very much so.
For whatever reason. So, Mr. President, the reality is that this was just one of many circumstances. Perhaps the same, let me not even speculate, but it's just one of many circumstances. And the ultimate result is that our energy security was just not addressed. So we now need to assess and redefine the refinery's future. And this can only be done by retaking control. This can only be done by ensuring that it is within our control to take the decisions. So between 2016 and 2017, various meetings were held, communications exchanged, and there were unsuccessful attempts at scheduling further meetings. We know that there had been letters written expressing dissatisfaction with the lack of action and urging conformance with agreements signed. Promises and commitments were made, but here we are today. It became clear that the priorities of the parties had changed. They became different, and the situation had become untenable. So, Mr. President, despite subsequent efforts to begin the upgrade from this end, we're also faced with the reality that the contracts did not include provisions that stated that if the upgrade didn't happen within a particular time, that the shares would revert to PCJ or anything. That's kind of a normal commercial clause that you would have tied in. There wasn't any of that type of clause. It didn't permit that, so that the government of Jamaica was prejudiced, in a sense.
Point of order, Mr. President. Point of order, sir. Very important point of order. The minister is disparaging the staff of the Attorney General's department, who no doubt must have been involved in drafting such an agreement. It's my understanding that that agreement had the blessing of the Attorney General's department, and these civil servants are not able to come here and defend themselves. The minister ought to do better than that. And it's imputing motives to them that is not needed, not called for. Leave the civil servants out of this. Come with the political game of selling the place to your friends.
Continue, Minister.
Thank you, Mr. President. Mr. President, I am 100% certain that the staff of the Attorney General's chambers know the faith I have in their abilities, because I work with them closely over the past 3 years to ensure that the work of this chamber is also done in good effect. So, well, Mr. President, Mr. President, Mr. President, clearly that 2017 agreement expired in 2018 without it being implemented. And the fact is that even in frustration, a sense of urgency last year, the PCJ had actually loaned, or rather taken a loan on from the Ministry of Finance of $100 million to try to implement that upgrade. Just phase one. US? In order to implement phase one, the vacuum distillation unit. But as you know, those funds have been returned to the Ministry of Finance, pending the decision of the Strategic Reform Committee, Review Committee. Mr. President, with all of those promises and recognizing challenges on the horizon, clearly, Mr. President, considering the background of this matter, we can't wait anymore. The fact is that 12 or 14 years later, 15, depending on where you count from, the upgrade of the refinery has not been undertaken, and the status of the refinery is now a risk for the economy or energy security. We have been running out of time for 15 years. So, Mr. President, I've outlined the need for an upgrade and steps that were taken to seek to pursue that. But I have to also highlight the changes in the landscape that created the risk and the urgency, because that is just one, that has only ever been one part of the context in which we're operating. Upgrade is one aspect of the upgrade, of the concerns in relation to Petrojam. Because you recall I mentioned that in 2004, then Minister Paulwell spoke about changes on the global landscape, regulatory landscape. The fact is that it had become clear, and this was one of the reasons that it became so urgent, that the International Maritime Organization made it clear that they would not be postponing, that they were implementing, as at January 1, 2020, new regulations regarding the sulfur content that can be had in heavy fuel oil. Without an upgrade, Petrojam would be unable to change how it refined heavy fuel oil. So as at January 1, 2020, it will, if nothing is done, not be able to sell HFO. It will not be able to refine it and sell it in the only way it can do, based on the equipment that it has in place now. So I've been saying that from that announcement on January 8th, that was one of the key risks to the operational risk to the, or rather the risk to the refinery's operations. That was one of the key risks identified on January 8th, Mr. President, and it's been reiterated, it's been repeated in different fora, it has been pointed out in the House and otherwise. Secondly, one of the changes in the landscape has, of course, also been the transition by the Jamaica Public Service Company to LNG in June of this year, scheduled to come on stream for June of this year. Recognizing that JPS comprises 50% of Petrojam's market, certainly that's a huge change. That's a huge loss that has to be accommodated. So their conversion to LNG is of significant impact to Petrojam. So these are two very major risks that have been pointed out at every step of the way. So I want to make it clear that when we speak about the importance of decision making, it's not made in a vacuum. And these things are real, and they have come closer and closer until they are now imminent. But Mr. President, the decision to proceed with this bill today is based not only on these technical issues, which will require risk mitigation and planning on the part of management, notwithstanding, because it is important, Petrojam is important to us in this stage that we are in. I've expressed that and made that clear. But there are also difficulties that are being faced by the energy sector arising from sanctions imposed by the United States Executive Order 13808, dated August 24, 2017. Those pose a real concern, and I'll bring us forward shortly. So the 2017 sanctions, and you'll remember when those came out, Mr. President, because when they came out, we were in the hurricane season. 2 to 3 weeks of oil supplies in Petrojam in hurricane season. Sanctions are issued, and suppliers start to say, whoa, what's the story with your relationship with the government of Venezuela and the share ownership here? Banks started to hesitate to supply, to allow transactions to be processed, and suppliers raised concerns. It is true, 100% true. The Ministry of Foreign Affairs and Foreign Trade, the ministry responsible for energy, the Office of the Prime Minister, Petrojam itself, and their external counsel that had been retained for the purpose in the United States had to work hard to seek to ensure that we were able to get just a comfort letter. Because remember, Petrojam was not defined as a sanctioned entity. It didn't fall squarely within the brackets. But the risk that was perceived by the suppliers, by the banks, by persons who would be fined, or if there were to have fallen afoul of the sanctions, the risk they perceived, those were real. And there's no action that can be taken that would have prevented them from taking the actions which they were proposing to take, which is to stop business transactions with Petrojam. So thankfully, we were able to work through that at that time. But it was challenging. And although we managed the issue into submission, the fact is that we have still had to answer concerns and provide that letter and indicate to new suppliers at each turn, or when banks raise the questions again, they had to be assured that Petrojam, notwithstanding its joint venture arrangement, was not a sanctioned entity and it was permissible to do business with them. And we should probably note that at this point in time, that is in 2017, August, in the wake of the executive order, it was around that time we would now have been close to 6 months into, around 6 months into the Kingston RUP agreement. There were challenges. Clearly, the Venezuelan counterparts were not undertaking their commitments. And at the same time, Petrojam itself was having a heightened operational risk threshold because of the sanctions. So then Minister Wheatley started discussions with his counterpart regarding repurchasing the shares, the government of Jamaica repurchasing its shares. So our efforts continued after that at both the informal and formal levels. So, Mr. President,
The Speaker's time has expired.
The Speaker's time has been expired. May the standing orders be suspended to enable her to complete her presentation.
The question is, the Speaker's time having expired, that the Minister be permitted to complete her presentation. In favor? Aye. Against?
thank you, Senator Morris. Thank you, colleagues. So, Mr. President, senators would be aware that the sanctions against PDVSA and related entities, such as PDV Caribe, have strengthened and expanded with the issuance of new executive orders since then, noting in particular those which were issued at the end of January of this year, January 2019, as well as the fact, of course, that other countries are imposing sanctions. Mr. President, in particular, on or around the 25th of January, a new executive order was issued which broadened the definition of the government of Venezuela to include, and I quote, any political subdivision, agency, or instrumentality thereof, including the Central Bank of Venezuela and PDVSA, and any person owned or controlled by or acting for or on behalf of the government of Venezuela, and to include any person owned or controlled directly or indirectly by the foregoing. So even beyond that now, any person owned or controlled directly or indirectly by the foregoing, and any person who has acted or purported to act directly or indirectly for or on behalf of any of the foregoing, including as a member of the Maduro regime. As a result of the new executive orders, and I shared this language, it's public knowledge, it's on the OFAC website, it is, they are in the public domain, and I shared this at the press briefing on the 14th, when I was clarifying, the 14th of January, when I was, the 14th of February, when I was clarifying the current circumstances in which we operate, and why the urgency of the matter now dictated that the matter come to Parliament, that we start that process. Because as a result of these new executive orders, there has been a new wave of concerns raised by the banks and suppliers. So payments to and from Petrojam have been subject to increased due diligence by primary suppliers of lines of credit, as well as intermediary banks. And the disruption or delay of transactions for Petrojam has become, let us put it lightly or delicately, Mr. President, a source of unease for their suppliers. So we're advised that one bank has advised Petrojam that it will only facilitate payments to a limited set of contractors, those which are already customers of that bank. And another major bank has advised Petrojam that it requires an uncapped indemnity, Mr. President, from Petrojam in order to continue to facilitate transactions. An uncapped indemnity. So let's understand the implications of this uncapped indemnity. An indemnity is where one person agrees to fully bear responsible for or to fully guarantee payment for in the event that something happens. And when it is uncapped, it means there is no limit. So if you indemnify a bank that is at risk of falling afoul of sanctions, or that could be seen to be at risk, or that could perceive a risk, and understand these sanctions and the fines. There have been transactions which I've heard of where the transaction is maybe $1 million, and then the fine is $1 billion. And that's United States dollars. Jamaica cannot absorb that risk. Petrojam cannot absorb that risk, and the taxpayers of Jamaica cannot absorb that risk. So signing on to that indemnity, Mr. President, would be a difficulty, let us say. And among other things, in that same agreement, Mr. President, that bank, because remember, there's more than one, and one has one set of issues, and another's another. That bank has also sought Petrojam's agreement to just acknowledge and absorb that it will and may, whenever it pleases, just stop providing transaction services, delay them, hold money, or not, or just terminate their services. So, while Petrojam might have sought legal advice on the extent of its exposure, I think it's quite clear from what we've expressed here in respect of the risk that if the ownership structure stays the same, Mr. President, and understand that the definition is wider and deeper than it was when we obtained the comfort letter. Petrojam could be prevented from undertaking its ordinary business, Mr. President, ordinary business if it doesn't sign the indemnity agreement. The situation is not a healthy one from a risk perspective. It is untenable, and further delays would be irresponsible. So, Mr. President, the facilitation by intermediary banks and ordinary banking services is again only one aspect, because we also have the supplier aspect. And as recently as last week, we have had circumstances where one supplier has said to Petrojam, listen, don't call me. We're not doing any more business as a result of the sanctions. Minister Williams read the email into the record in that other place. In that other place. These are the facts. These are the facts. Not to mention the concerns raised by other suppliers, wherein Petrojam has now been trying to send out notices to say, we're not a sanctioned entity, we're not a sanctioned entity, so you can do business with us. That's where Petrojam is now, trying to unruffle feathers while companies are taking legal advice. And the fact is that they can at any time, they are companies, they assess risk, and they assess the fine, and if it is not worth it to them to do business with us, they don't care if Jamaica, at the end of the day, if Jamaicans can turn on a light switch and turn the key in their car and drive. For them, it's about their bottom line. So it's important. And why is it they're concerned? They're concerned because of the current ownership structure. The structure which this bill before us today will change. Mr. President, the fact is that if Petrojam is not able to obtain the goods and services which it requires to provide services to Jamaica and Jamaican companies, then our security is prejudiced and compromised. Mr. President, we're now at the point of pursuing this last resort option. So, Mr. President, I want to now turn to the matter of the offer of shares, because we have made clear and we have stated at every step of this process that even as we started a legislative process, and even before we started, we have said that as we go through it, we are still open to discuss. We are still open to entering into an agreement. The owner of the shares. The owner of the shares. So, Mr. President, the purchase. The purchase. We have not achieved the desired outcome, is what I'll say, Mr. President. In the first place, in the first instance, I would say, this was because the price that was being insisted on by PDV Caribe was more than 10 times the fair market value. More than 10 times the fair market value that had been determined by the most recent independent valuation report issued in 2018, using the methodology. And let's make this clear. Let's make this clear, colleagues, because you need to understand this. You need to understand this. That this valuation report was using the same methodology that was used to sell them the shares in 2007. The same methodology. It used the income approach, which is one as is, no major upgrades, as it was then, because one was uncertain, 22-year life period of the refinery looked at, and that's the life that was looked at for both for the valuation reports. As is, no major upgrades, because clearly the economic prospects are uncertain. So clearly, one could never justify to the Jamaican people a price that's 10 times fair market value, determined by an independent valuation report done by a globally respected company with experience, extensive experience in valuing assets within the energy sector. One that had been used by PDV Caribe and by PDVSA in other jurisdictions all over the world, and had also been involved in the valuation in 2006, the one that was used to sell them the shares. So same company involved, same methodology, the income approach, and again, not anticipating any upgrade. So, Mr. President, as I'm discussing this valuation, it's important for me to clear up some misunderstandings that are in the public. And I want to refer to the valuation for which the same Muse standstill was engaged on February 3rd, 2017. So, Mr. President, February 2017 is now just where Prime Minister Holness and President Maduro have just signed the letter of intent. And the teams are working on the agreement that's going to come pursuant to that, the one that was signed in the same February 2017 for the upgrade. So Muse standstill, it was agreed between the parties that Muse standstill would be engaged by Petrojam. So understand, this is the parties are retaining, Petrojam is retaining Muse standstill to value the refinery for the purposes of securing the loans or investment that would be needed for the upgrade that would be done under the agreement. So what do? They use the same income approach, but you know what the income approach does? The income approach, as I just explained, looks at the projected cash flows over a period of time, over the life, what is called the life in the technical term of the refinery. So, what does it project, which is so different from the one done in 2018? It is being done in the context that the refinery is going to be upgraded now. And what does that mean? That in 2020, there will be in place a vacuum distillation unit, which does what? The vacuum distillation unit would allow Petrojam to comply with the IMO regulations. It can still sell HFO because the HFO that it refines will now be compliant. Wow, amazing. So it could still refine and it could still sell and it would still have its markets. What could it do? It can expand its capacity and sell more asphalt. Wow, it can produce more asphalt. It can sell internationally and be producing for the market in a much more effective way, which would do what? Mitigate against the losses that are going to come on stream if nothing is done and JPS switches to LNG. So the loss of the 50% of that market plus the impact of the IMO regulations are avoided because you would have a vacuum distillation unit in place. A valuation. So this is February, when the agreement is still valid. So, Mr. President, that was not, but it is crystal clear. The actual the report. Mr. President. Mr. President, in January 2018, so January 2018, when we were just, let us say, a month out now from the expiry of the refinery upgrade project agreement, the RUP agreement. Remember that expired in February 2018. So in January, February, Muse was re-engaged by Petrojam to update that valuation report, because by now it has become clear that that upgrade is not on the horizon. PDVSA was not meeting its commitments. Minister Wheatley was already discussing with his counterpart, was discussing with him, would they sell us back the shares so that we could take control and treat with things differently, since it was clear that they were no longer interested in the upgrade. So Muse was asked to update that valuation report. And they were asked to do it on an as-is, no major upgrade basis, because that's now what you would take as the presumptions. So again, using the same methodology, which is the income approach. And I make a point of that because the income approach is recognized as the most important methodology to be used for a revenue generating asset. So, Mr. President, so what is different now? And we recognize that a valuation report, a valuation takes certain facts and makes certain presumptions. And we're now looking at no VDU. So no major upgrades. And what does that mean? It means that the risks that we've been saying, the real operational risks that we keep speaking about, but somehow it seems that some people just refuse to process the risks as a reality. So we've said it time and time again that changing the IMO regulations would mean that Petrojam couldn't operate this way if nothing were done. So if there is no VDU in 2020, the refinery operations would have to cease. That's what was there if nothing were done. The same issue would arise as a result, or rather a similar impact would have to be taken into consideration in relation to the transition by JPS. So, Mr. President, the change in value, again, because you are projecting cash flow, and you're saying it can't sell after 2020 if it can't comply with the IMO regulations. Yeah. It's going to lose 50% of its market because JPS is switching. And even though, from a management perspective, we know they're going to be working on some risk mitigation and planning and scenario planning in order to try to absorb risk and try to mitigate risk. The fact is that you're looking ahead with a different future. So, Mr. President, that is how you account for the difference between 2017 and 2018. One says there's a VDU in place, one says there's no VDU in place in 2020.
That's point of clarification.
So where we are now,
point of clarification,
where we
Mr.
are
President.
now.
Point of clarification. Point of clarification. Could the minister indicate to us if those are the reasons why the Prime Minister didn't tell the other ministers about it?
Senator Brown, continue, Minister.
So, Mr. President, I think it's important also, as we're dealing with a fact-based presentation, that the 2017 valuation was not relevant for the purposes of the sale. And I want to explain that while persons are speaking about transparency outside of what should be made public, etc., I've already gone through and explained the realities of how a negotiation is conducted and what information is relevant to share. So the 2018 valuation was relevant for the purposes of the shares. And that valuation report was shared with our counterparts. As part of the negotiation, we had in fact several meetings where we went through and discussed the projections and the different perspectives. So that's how a negotiation between parties is conducted. It can't be done in the public. So, Mr. President, I don't know why anyone would want to undermine trust in a process that is seeking to get the best deal for the Jamaican people in a fair way. And why do I say fair? Because there can be nothing unfair. There can be nothing unfair about obtaining an internationally recognized and experienced valuator to use the same methodology to value an asset which it used in 2006 to sell to a party when you are now valuing to repurchase. Anything else is irrelevant to the process, Mr. President. And those are the facts. Those are the facts, Mr. President. So, Mr. President, Mr. President, sorry, you're telling me you don't believe me? Is that motive? No, that you just said it. Is that imputing motive? Do I take a point of order? Because you're now impugning my character. Listen now. No, I heard you very clearly, and I'm sure Hansard would capture it, and we will deal with it. But Mr. President,
Nigeria,
notwithstanding the sensitivity of the issues that we have had to be dealing with, we were pleased to announce recently that we had reached an accord on a settlement price. This is a settlement price, a settlement amount. Not the value, it's a settlement price. Negotiated. And Mr. President, regretfully, we were, however, unable to move from that point. We were unable to agree on the terms by which this agreement, would be based. And ultimately, we reached a difficulty in the manner of remittance of funds. So fundamentally, where we reached was a situation that if we had signed an agreement in the terms which they had wanted, we would have paid out funds which may never reach them and which we would no longer have. And we would have no shares. So nobody would have anything. Jamaica would have no shares and Jamaica would have no money. And the shares would be gone. They wouldn't transfer the shares if the money wasn't paid into their account. And if you can't pay the money into their account, then they won't transfer the shares. How you see any other result from that? So, Mr. President, we had put on the table the possibility of an escrow arrangement, but it has not to date been agreed. Mr. President, I want to just say what made it clear, the circumstances which made it clear to us that it would have been difficult or impossible. Impossible is probably the better word, for such a transaction to be agreed. Mr. President, in trying to go through and understand how we would implement the agreement, we recognize that the Petro-Caribbean Development Fund, since the middle of last year, had been unable to remit funds to PDVSA under the Caracas Agreement. They had tried to send it, and it had bounced. They tried to send it in US, they tried to send it in euros, they tried to send it to different banks outside of the US, outside of countries in Europe, and the monies would not go through. So the Accountant General had to hold those monies, and then, of course, to be placed, for them to be placed in escrow. And in December last year, Petro-Caribbean Development Fund also tried to make its Petro-Caribbean debt repayment under the Petro-Caribbean arrangement. And those monies are still held by an intermediary bank, because although the Bank of Jamaica has said, please send the money back, you have said that you are investigating sanctions for possible sanctions infringement, and that was the reason that they gave for holding the money. We have said to them, okay, don't pay it through, just send it back to us, and they still have not released the funds. We hope they will, but it has not been done. Mr. President, that is the point. We cannot rely on hope. That is why we have to move forward.
Minister, I bring to your attention the fact that it is 1:20.
Mr. President, the time being 1:20, I ask that the Senate be allowed to sit beyond 1:30 p.m. to complete the business of the day.
Thank you. The question is, at the time being 1:20, the Senate be allowed to sit beyond 1:30 to complete the business of the day. Those in favor? Aye. Against? Minister.
Thank you, Mr. President. So, Mr. President, where we are now is that the government of Jamaica, having attempted to enter into an agreement with PDV Caribbean SA for the repurchase of the 49% shareholding which they have in Petrojam Limited, having pursued several diplomatic initiatives at the highest levels which have been unsuccessful, and those include no less than 4 heads of government. Mr. President, having written letters at the technical and ministerial levels across the years, having waited more than 12 years with no indication that the upgrade will be conducted or pursued under the agreements which exist, having made Petrojam's teams available for meetings which have not been attended or respected, Mr. President, having been seized of the fact that Petrojam will in 2019 lose 50% of its market, having been seized of the fact that in 2020 the IMO sulfur content regulations will be in effect and will change Petrojam's market prospects, having been advised, Mr. President, that in no uncertain terms of the potential termination of services by suppliers and banks which would cripple the refinery and severely impact the Jamaican economy, the government of Jamaica has reassessed its legal options. It's clear to anyone monitoring the geopolitical developments in the region that circumstances have not been improving over the last 2 years, and in fact, over the last 2 weeks. So, however quick or lengthy a process that will be needed to resolve the issues which exist in that sphere, time is run out for Petrojam. We have to take action now to protect it. This is, Mr. President, we've said it before, but we need to say it again, that this is not a political issue for us. The government is focused on Jamaica's economic stability and our energy security, which are necessary for the well-being of Jamaicans. We cannot be sidetracked sidetracked by assertions of political intrigue and unmeritorious allegations of bending the knee to other states. Mr. President, simply put, we are here to take a responsible decision in the interests of the Jamaican people, not to perpetuate any act of hostility or any political statement. Mr. President, I want to state also for the record, and this has been shared with our bilateral and development partners who understand, Mr. President, they've expressed that to us clearly, that this action does not reflect any change in our free market policies or our belief and support in property rights. Mr. President, the fact is that the power is given by the Constitution. The Land Acquisition Act was developed in that, even in a similar context. There is a quite clear reason on the table for making this recognized as a specific and isolated act brought about by a confluence of circumstances, including the huge financial risk of running afoul of sanctions. Jamaica cannot absorb that risk. Jamaica cannot absorb, although we are experiencing 15 consecutive quarters of growth. Our growth is fragile, and we need to protect it, Mr. President. So the bill before us is drafted to reflect this very narrow scope. It is in no way intended to set a particular precedent for similar actions. It is drafted specifically. I think it has been made clear that we are not acting prematurely or hastily. There's been too much time wasted already by previous administrations. So we are taking action now to make sure that we have petroleum products to power our homes, our schools, our businesses, our places of work, and to make sure that we can get there to and from. So, Mr. President, at this juncture, within the context of these considerations, the government of Jamaica will compulsorily acquire the 49% shareholding in Petrojam Limited, wherever it may be held, for the public purpose of securing Jamaica's energy security by way of enacting this legislation. And Mr. President, yes, it is the first time that a matter like this has arisen for the Parliament to acquire property in the nation's interests in this way. But because it is unprecedented does not mean that it is not the right action. Mr. President, the Constitution of Jamaica clearly allows for it, and as has been expressed in that other place, the framers of the Constitution considered the protection to be offered to a person's property rights and decided that those rights should be protected in the Constitution through the payment of compensation, which is provided for in the bill before us. Simply put, Mr. President, the Constitution does not prohibit the compulsory acquisition of property. It does, however, state that the legislation should provide for, 1, the manner in which compensation is to be determined and given, and 2, access to the court for the purpose of establishing a person's right or interest in the property, the amount of compensation to be paid, and the enforcement of that right to compensation. So we're not seeking to take property without paying for it, and the bill before us provides a clear mechanism for compensation as required. It has perhaps a supplementary mechanism, but it certainly provides for what is required by the Constitution. And in good faith, as a matter of fact, Mr. President, what it even does is it provides for monies to be paid into escrow on day 1 when the act comes into effect. So, Mr. President, it's important that we note that the bill before us today has been carefully crafted to achieve the primary purpose of achieving Jamaica's energy security. The bill provides for the acquisition of shares in Petrojam not held by PCJ. So the bill is not intended to be of general application to this or any other sector or any other company. in any sector. In fact, the government is aware that if it were not drafted in this way, it could be perceived as being broader in scope and demonstrating another type of intent, a change in policy, which it does not. So, Mr. President, I want to point out that the reference to persons other than PCJ, so the bill speaks about the acquisition of the applicable property being the shares held by persons other than PCJ. And it does so in the long title as well as in the definition section, in the definition of applicable property. And this was done out of an abundance of caution to ensure that any attempt to transfer the shares to a third party would still not prevent the operation of this act when it comes into effect. So, Mr. President, Clause 1 of the bill sets out the short title, while Clause 2 contains the definitions of certain terms that are used throughout the bill. And of significance, again, we speak about the applicable property, which I've just described, and Mr. President, Clause 3, compulsory acquisition of the applicable property and payment of the value into escrow account, a clause which was pointed out earlier, provides for the immediate vesting of the shares in the Accountant General, free from all encumbrances, which will be held on trust for the government when the Act comes into operation. And it's further important to note that at the same time, the Minister with responsibility for finance will also be required by the Act to cause the amount of the value of the property, of the applicable property, to be paid into an escrow account, which for the purposes of the Act will be an interest-bearing account at the Bank of Jamaica, established by the Minister with responsibility for finance. 3.3. I did. I said 3.3. I said 3.3. Maybe I was whispering in turn. So the amount to be paid into escrow will be taken from the consolidated fund or such other source of funds available to the government and which the government deems to be appropriate in the circumstances. So the payment into escrow is not necessarily something that's required by the Constitution, but for us it was a mark of good faith and a mark of clear demonstration of the intent to pay for the shares. So, Mr. President, Clause 4 deals with compensation. And it states that in respect of the compulsory acquisition of the applicable property, compensation will be required to be paid out of the consolidated fund, out of the escrow account. However, if the compensation required to be paid is in excess of what is paid into the escrow account, then that excess will be paid out of the consolidated fund or from any other source available to the government and which the government deems to be appropriate in the circumstances. Now, it provides as well that the compensation to be paid to interested persons will be done by way of an electronic transfer in the currency of the United States of America or any other freely convertible currency. So, Mr. President, the clause further sets out the procedural steps required on the part of the Minister with responsible for energy and any interested person upon the coming into operation of the Act. In Clause 4, it's to be noted that within 30 days after the passage of the Act, the Minister with responsible for energy will be required to publish a notice to state that all claims to compensation for the applicable property may be made to that Minister, and the Minister will be required to specify in that notice the time within which such claims may be made and the particulars of the property. And while it's anticipated that there should only be one legitimate claimant, because these are shares, it's not property at large like, you know, it's a piece of land and you wonder who might lay claim to the land. We also know that shares are transferable We also know that there are circumstances where you can have more than one claim. And it was therefore important for the bill to be crafted in a way that didn't tie the hands of the government if circumstances came up which didn't fit with exactly how you would imagine that the transaction should take place. So it was given some room for the reality in which we exist, where things regretfully don't go according to plan or are not as you have been told they are. So, Mr. President, while therefore the bill is drafted in language to refer to interested persons, notwithstanding understanding that there should only be one holder, one interested person, the bill has been drafted to ensure that if anything has occurred which we did not readily anticipate, then we can still ensure that the relevant actions are taken. So, Mr. President, Clause 4 outlines what would be required of an interested person where a claim is made to compensation. And it's also important to note that where the minister determines that an injustice may arise if a claim has not been considered within the 3-month period that's provided in the notice, then he may, of course, enlarge the time. And, Mr. President, this is part of what we would describe as a supplemental process that would allow for a shorter process if indeed the process is uncomplicated and the interested party that we would anticipate comes forward and engages with the minister, and that decision is taken in respect of the monies paid into escrow one way or another. So, Mr. President, Clause 4 provides that on the expiration of the 3-month period, the minister must consider any claim that has been made and make a determination on the amount of the compensation payable and serve a written notice on the determination, notice of the determination on the interested person, unless the circumstances are such that the minister applies to the court for a determination to be made in respect of the person's interest. And the clause empowers the minister to also request additional information in that process. So this is where the interested party, although it has access to the court, because that has not been excluded, and that remains throughout, we'll get there, but the process is that if they don't want to go, then we have created a supplemental process whereby the minister may resolve the circumstances. So, Mr. President, the clause provides, of course, that it's an offense if persons make misrepresentations or if they support false documentation to claim an interest that they don't actually have. It's an offense for them to so do. And, Mr. President, the written notice, which I just spoke of in respect of the minister, that is any determination which he has made, must specify the amount of compensation determined to be payable to the interested person, the value of the applicable property, and the apportionment of compensation among interested persons if there is more than one. Mr. President, the written notice must also offer to pay compensation awarded to the entitled persons and specify the time frame within which persons are required to indicate their acceptance or rejection of the offer and inform of their right to apply to court, among other things. Mr. President, of course, if the interested person accepts the offer, the Minister of Finance, upon the instruction of the Minister with responsibility for energy, shall in writing cause the compensation to be paid. And finally, Mr. President, in relation to this clause, the government has taken the position that no compensation determined or paid will be charged with stamp duty or transfer tax. Mr. President, Clause 5 of the bill sets out rules for determination of compensation, detailing the matters that shouldn't be taken into consideration in determining them, as well as matters that should be taken into account. And the clause sets these out, Mr. President. It's important to note that the clause requires that the value of the applicable property will be taken to be 49% of the fair market value of the Petrodam Limited, based on the income approach, which we have already discussed today, that international valuators the world over determine it to be the best process, the most important process to be used in valuing a revenue-generating asset. And it was, in fact, the approach used for the sale of the shares in 2007 and accordingly appropriate at this point in time. Mr. President, Clause 6 of the bill grants the minister with responsibility a right to have reference to the court should he or she require its assistance in determining any issues related to compensation. And of course, the interested party has access also to the court to determine any matter related to compensation, which it may seem. So Clause 6 of the bill also grants, Mr. President, that would be repetitive. Mr. President, Clause 7, in respect of the court's conduct of its assessment, Clause 7 provides for the court to be able to appoint 2 assessors to support it in determining the amount of any compensation where an application is made to the court by an interested person. And Clause 8 provides that the amount awarded to the person by the court cannot exceed the amount which has been claimed. Mr. President, Clause 9 deals with services of the notice, and Clause 10 of notices, and Clause 10 creates an offence for willful obstruction of any action taken in respect of the applicable property, Mr. President. Mr. President, the bill has been carefully considered and drafted so that it adequately satisfies the provisions of 15(1)(b) of the Constitution of Jamaica, which, as I've explained earlier, requires that any law which seeks to compulsorily acquire property of any description must secure to any interested party claiming an interest or interest in or right over such property a right of access to the court for the purpose of 1, establishing the right or interest, 2, determining the compensation, if any, to which he is entitled, and 3, enforcing his right to any such compensation. Mr. President, we're at a point where Jamaica can no longer hope or wait or count on others to act in our interest. We're in a uniquely difficult position, but we have to act responsibly and act in the interests of our citizens. And it is in this context that I now commend this bill to the Senate for its approval.
Thank you. Thank you. Thank you very much, Minister. Senator Knight, please. Senator Hill and Senator Samuda, would you allow me to do the government work? I mean the people's work? Minister, thank you very much. Senator Crawford.
Thank you, Mr. President. Mr. President, very little truth has been spoken here.
On a point of order, Mr. President. Mr. President, the senator is imputing motive unless Mr. President, he should withdraw that statement on a point of order. Unless he's referring to his colleagues.
No, his colleagues.
Point of order. Point of order. Point of order. Point of order.
There is a point of order on the floor, Senator Brown.
Yeah.
The minister is. Could you have a seat, please?
Oh, sorry.
The minister has asked that a statement by the Speaker which suggests perhaps that it is at best unparliamentary to stand and say, what did he say? That there was no truth or very little truth has been spoken. So what, Senator Crawford, continue please in a more parliamentary vein.
Sorry, but I raise a point. No. President, I did raise a point of order. You asked me to sit because you wanted to.
What is your point of order?
The leader of government business has made comments about the opposition that is unparliamentary.
You can't have you can't have your cake and eat it.
I want to put my point of order. I want to put my point of order. I don't want you to rule on it before you hear it, because that's not fair. I want you at least to hear my point of order, then you may rule on it. But the leader of government business has said some things about the opposition that is unparliamentary. It's unbecoming of her. It doesn't bode well for cooperation. And I'm asking you, Mr. President, to ask her to withdraw that comment. Because if she does not, then you have to recognize that you are giving license to all of us in the Senate to behave unparliamentary. That's not what you desire. But what she did is disgraceful and becoming of a leader of government business. And I ask that she be required to withdraw it.
Senator Brown, I know that by looking at you, you are making that point of order tongue-in-cheek.
No.
The speaker.
Mr. President.
You know what? You said, I hope that you say what is happening.
Mr. President.
I hope. No, I have not finished, Senator Morris. I have not finished. You cannot have your cake and eat it. I have asked, Senator Crawford said something and the minister responded to it. And I have pointed out that we need to be a bit more parliamentary in our debates. Continue, Senator.
Mr. President.
Mr. President, if she doesn't withdraw that unparliamentary statement, she's going to have to meet without me. If she calls us liars, and can't, and doesn't have the courage and the decency to withdraw it.
Senator I did not order. Anyway, look here.
A point of order.
Listen to me. Listen to the ruling here now. I recognize exactly what is happening. Senator Crawford, continue.
Everybody walk out. All they walk out. Senator Crawford can't give a visit. That's what you want to do from being in your parliamentary duty. That's what you want to do from being.
Hello.
A point of order.
Look here, I'm entitled to make an observation, and the observation that I make is this. What has happened is a sad moment for the function. What has happened is a very sad moment for the function of the democracy and the Senate, but the foundation for this was being laid very early. Senator Crawford in his statement said that that there was no untruth spoken in this Senate, a little very truth. And the leader said, well, he must be speaking about his opposition counterparts. And the result of this is this walkout. Now, it seems to me that although there is a dramatic intent, the business of the country must continue. Minister? Minister? Minister?
May I just ask, Mr. President, for suspension? Oh, my apologies. May I ask for just a 2-minute recess, craving your indulgence. Well, 1 minute. If I could just crave your indulgence. 1 minute, please.
The sitting of the Senate is suspended for 1 minute.
No, it's fine. Okay. No. Sorry, I just confirmed something, Mr. President, with the whip. My apologies. Mr. President, as there... No suspension, no. As there are no matters to which I must respond, and having made a comprehensive outline of the circumstances within which I seek the approval of the Senate, Mr. President, I ask for second reading of the bill. My apologies.
Thank you, Minister. The question is that the bill be read for a second time. Those in favor? Aye. Against?
A bill entitled An Act to Provide for the Compulsory Acquisition of the Shares Held in Petrojam Limited by persons other than the Petroleum Corporation of Jamaica and for connected matters, read a second time.
Thank you very much, Madam Clerk. The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. Can I ask for your attention, please? I put clause 1 of the bill. Those in favor? Aye. Against? Ayes have it. I put clause 2 of the bill. Those in favor? Aye. Against? Ayes have it. I put clause 3 of the bill. Those in favor? Aye. Against? Ayes have it. I put clause 4 of the bill. Those in favor? Aye. Against? Ayes have it. I put clause 5 of the bill. Those in favor? Aye. Against? Ayes have it. I put clause 6. Those in favor? Aye. Against? I put clause 7. Those in favor? Aye. Against? I put clause 8. Those in favor? Aye. Against? Ayes have it. I put clause 9. Those in favor? Aye. Against? Ayes have it. I put clause 10. Those in favor? Aye. Against? I put the title and enacting clause. Those in favor? Aye. Against? The question is that I do report the bill as having passed the Senate stage. Passed committee stage without amendment. Those in favor? Aye. Against? I do report the bill as having passed committee stage without amendment. The question is that the bill be read for a third time. Those in favor? Aye. Against? What? You didn't. I read your mind. You want to go ahead and do that for me, please? Just go ahead and do that, please. Ask for the third reading.
Mr. President, might the bill be read a third time?
Thank you very much. The question is that the bill be read for a third time. Those in favor? Aye. Against?
A bill entitled An Act to Provide for the Compulsory Acquisition of the Shares Held in Petrojam Limited by persons other than the Petroleum Corporation of Jamaica and for connected matters, read a third time and passed.
Mr. President, I believe we had all thought we would be here a lot longer today. Well, Okay. Well, yes, but before. But it is not intended to do any further business today, Mr. President. Might the Senate be adjourned for a date to be fixed?
Thank you, Minister. The question is that the Senate now be adjourned for a date to be fixed. Those in favor? Against?
I would like to see every crime finish in Jamaica. And the children them, oh boy, it would be a happy world for them. Jamaica is very beautiful and nice, you know. There is nowhere like home. This place is paradise, you know. It's just the crime that really keeping us scared. Let's create a safer Jamaica.
A message from the Ministry of National Security.
Keep we island clean, so clean. From the peaks to the beach, so clean. No dirty up Jamaica, please don't do it. Keep we island clean, so clean. From the peaks to the beach, so clean. No dirty up Jamaica, please don't do it.
No dash no paper, no dash no plastic. Dispose your garbage responsibly. No know how to recycle, learn it quick. And if you drop it, better pick up every piece of it. Plastics last forever, don't forget the bits. Cause when them touch the street, them end up in the sea. Collect pan the reef where they fish them feed. And when you want seafood, I eat your
Keep
eat.
we island clean, so clean. From the peaks to the beach, so clean. No dirty up Jamaica, please don't do it. No dirty up Jamaica. No dirty up Jamaica. No dirty up Jamaica. No dirty up Jamaica.
What happened, Tristan?
Mommy, what is an activate?
Activate? Where you hear that word?
A lady was on the TV and she said she is a children's activate.
Oh, the advocate.
That's what I said.
Okay. The children's advocate is the person who makes sure that people know and respect the rights of children. She also makes sure that they are protected. She makes sure that even the government does its job properly when it comes to kids.
Children have rights too, Mommy?
Of course.
So, Mommy, do I have the rights to a little ice cream?
Right now, you have the right to go to bed.
Be an advocate for children's rights. An invitation from the Office of the Children's Advocate.
You never put up a fight, no.